What's up, everybody? It's Peter Tragos, the lawyer you know, and on this channel, we break down the trials and cases you care most about so you can understand how the American civil and criminal justice system works. And we try to make sure you understand what your rights are in every situation, which is why we try to walk you through the entire legal process while also answering your insightful questions along the way. And while it's not legal advice, it's always exciting. So buckle up for another episode of The Lawyer You Know. What's up, everybody, and happy Monday. We are back at it here for another week of just jam-packed legal content. I cannot believe there's this much to talk about in the law just in our country, as every weekend the messages, the documents, the filings, the pleadings just flood my inboxes on Instagram and Twitter. Tragos Law right here if you want to join the party and sending it in. So today we are talking about the Idaho 4, the Brian Kohberger case. A lot's happening. We are going to look at the state and the defense's response to Shannon Gray and the victims and others who have objected to this gag order as unconstitutionally vague and as violating their First Amendment rights. As you can tell, my voice is not fully back. I'm feeling good, but not sounding good just yet. I still have some tea that my wife made me that I'm drinking. So I will continue to take some sips there as it keeps my voice in better order here. So we're going to talk about that today. We're going to look at the response from the defense. We're going to look at the affidavit filed by the state. And we are also going to look at potentially what people are telling me as a termination letter for Brian Kohberger. We're going to look at it because I think it's really interesting. I think the timing and the timeline of it is really interesting. To me, it has not been deemed admissible or reliable yet. I haven't seen any official filings with this, but it seems legit and it could really fit into this process and potentially be important. So if you guys are interested in this Idaho content, please hit that like button for me and subscribe to our page if you haven't already. We did hit 200K, which is amazing and so fun and a testament to you all. Get in the comments any questions that you have or any comments about this case that you have. We are going to be doing a 200K celebration at some point. We're trying to plan it to make it something fun for you all to watch and hang out with. But without further ado, let's go ahead and jump into this Idaho content. We're going to start with the affidavit of the Latah County prosecutor, William Thompson. Let me put it up here on the screen. So what an affidavit is basically is just like a sworn statement. You can think about it in a deposition type of situation. A lot of times we do stuff like this in lieu of a deposition in cases for people that are going to be witnesses, or attorneys in this situation can also file affidavits just so the court can know officially what their stance is and where they stand on a particular issue. And this is an affidavit of Latah County prosecutor William W. Thompson, who says, I, William W. Thompson Jr., being duly sworn, do hereby state the following information is true and correct to the best of my knowledge and belief. And that's important because, as we know, when you swear under oath, you're under penalty of perjury. So we want to say, as far as what I know, as far as I understand, and to what I know at this point, this is who I am. I'm the elected prosecutor and have served in that position for approximately 30 years, which is wild. In that role, I am one of the attorneys representing the state in the above titled matter. And then here's the big part, number 3. The members of the Gonsalves family who are represented by Mr. Shannon Gray are potential witnesses in this case, including at trial and or sentencing, especially sentencing, right? Where we have the victim impact statements. Like we know they're going to be witnesses at the sentencing phase if we get there. And the reason he's saying this is because the judge made this order to include parties and potential witnesses. He is saying they absolutely fit into potential witnesses. And they're almost a sure thing to be a witness at the sentencing phase. So this is important. The judge needs to know this to keep an accurate record, to make sure this stuff is constitutional, to make sure there's no major issues. Now, it's not going to really be an appellate issue where Kohberger might get off if he gets convicted or stuff like that we need to worry about, but we do want to protect people's rights. That is one of the most important, that's probably the most important thing, right? Justice is the most important thing to some people, and protecting other people's rights is the most important thing to other people. And I would say you can't have one without the other. You can't have justice unless you're protecting people's rights. And you can't protect people's rights without justice. So that's part of the balancing act that we're doing here. But it's important that the state prosecutor makes this affidavit so that we all know that they are, in fact, potential witnesses. We do not have to speculate. Okay. So taking that in conjunction with the next document we're going to put on the screen, which is the defendant's response to Shannon Gray's objection and attempt to appeal that second gag order. Let's zoom in a little bit. All right. So objection to motion to appeal, amend, and or clarify non-dissemination order, aka gag order. Comes now Brian C. Kohberger, buying through their attorney Jay West and Logston. And you'd be like, whoa, what? That's not his attorney. That's impossible. We all know about his attorney at this point. It's Ann Taylor. She is the public defender. Logston is her chief deputy, which basically means like top assistant. And this is just another example of a lot of lawyers work on these cases. There's a lot of public defenders in the public defender's office. They help each other out. It's not just one lawyer doing all the work. Okay. And hereby object to the motion to appeal, amend, and or clarify the non-dissemination order filed by Shannon Gray as counsel for the Gonsalves family. This objection is made on the grounds that the non-dissemination order properly requires Mr. Gray to abide by the clear requirement of the ethical rules of the state. It's so funny. We're seeing it a lot in the Murdoch trial, how both lawyers are like, this is clear. This is easy, Judge. And the judge is like, well, if it was so easy, I don't think you'd be arguing about it. The court's order is not violative of Mr. Gray's First Amendment rights. In his memorandum in support of the motion to appeal and or clarification on amended non-dissemination order, Mr. Gray contends that because his clients, the Gonsalves family, are classified as non-party citizens, application of the court's non-dissemination order to him constitutes a prior restraint on his rights to free speech under the First Amendment. In support of his position, Mr. Gray cites the fair trial and public disclosure provision of the ABA standards for criminal justice, as well as the precedent established in Shepard v. Maxwell and these other cases. The issue at hand may be summarized as follows: whether application of a non-dissemination order to an attorney representing the family of the alleged murder victim constitutes an intolerable prior restraint on speech. Now, some of this we agreed with, some of this we didn't. As we go through here, I have a pretty good idea of what I would do if I was the judge. Of course, not a judge, never going to be a judge, but I think I have something that could potentially be a solution that nobody would be happy with, but everybody would be content with potentially at the end of the day. And again, if it bothers you that I drink while I do this, I apologize. But it does help clear my throat and keep it easier for you to understand and the volume better. And I will tell you, you don't have to feel bad for me for coming on here and talking because my voice sounds like it hurts. I was excited to do this. Told my wife when I left the house this morning, I was like, I'm excited to read through this. I haven't read through all this. So we're kind of reading through this together for the first time. We're going to read the termination letter. We're going to read through this together. And I'm excited to talk about it with you guys and see what you think and see how you think all this fits together and which side of this gag order you think is right. So in order to do that, in order to do it today, in order to do it together, I got to take a sip on my tea as we read. We're spilling the tea and drinking the tea. All right. The First Amendment prohibits laws abridging the freedom of speech, while the Sixth guarantees to the criminal defendant the right to a speedy and public trial by an impartial jury, occasionally in conflict where protected pretrial expression threatens the impartiality of the jury. The United States Supreme Court has determined certain parties' First Amendment rights may be limited when exercise of those rights would result in prejudice to the defendant, noting, with his life at stake, it is not requiring too much that the defendant be tried in an atmosphere undisturbed by so huge a wave of public passion. Obviously, we agree with this. More important than them being able to say what they want to the media is that Brian Kohberger or any defendant gets a fair trial, gets a fair and unbiased jury. But are there ways that we can limit the exercise of those rights, that it says limit this free speech without taking it away completely? That's the question I want you to have in your head as we read through this and we kind of point towards what I think the right move from the judge would be. As a means of reducing the appearance of prejudicial material and to protect the jury from outside influence, a trial court may prescribe extrajudicial statements by any lawyer, party, witness, or court official, and may also promulgate a regulation with respect to dissemination of information about the case. I think that was a typo. The cure lies in those remedial measures that will prevent the prejudice at its inception. That's what we're trying to do. Put together remedial measures, meaning to fix that which will prevent the prejudice at its inception. That's our goal. One such measure at issue here As in Stewart, this court is presented with a confrontation between prior restraint imposed to protect one vital constitutional guarantee and the explicit command of another that the freedom to speak shall not be abridged. Unlike in Stewart, however, the regulation at issue is as to an attorney who may be subjected to greater limitations than could be imposed on the press, as the Supreme Court noted in Shepard. The courts must take such steps by rule and regulation that will protect their processes from prejudicial outside interferences. Neither prosecutors, counsel for the defense, the accused, witnesses, court staff, nor enforcement officers coming under the jurisdiction of the court should be permitted to frustrate its function. Collaboration between counsel and the press as to information affecting the fairness of a criminal trial is not only subject to regulation, but is highly censorable and worthy of disciplinary measures. Now, is this correct? Answer, yes. But is there not a way? Actually, I would say if I was Shannon Gray, you're right. This rule is already in place. I am not allowed to do something that will affect the fairness of this trial. And the way I talk to the media, I don't think affects the fairness of this trial. I am not going to say anything unethical. I'm not going to say anything illegal. I'm not going to violate any confidences or confidentiality or privilege. But that doesn't mean I shouldn't be able to speak on behalf of my clients about this case at all or make any extrajudicial statements. The Supreme Court found the speech of lawyers representing clients in pending cases may be regulated under a less demanding standard than that established for regulation of the press in Stewart and cases which precede it. Lawyers representing clients in pending cases are key participants in the criminal justice system, and the state may demand some adherence to the precepts of that system in regulating their speech as well as their conduct. I agree. They can limit it. Let's find ways to limit it, but still allow them to make certain comments that maybe the parties can't make, that the state, the investigators, the people on the inside, or the defense and their investigators and experts, people on the inside, they can be more limited than somebody who's going out who very clearly does not have all the evidence and all the information in the case, like the victims. In an attempt to exclude himself from these holdings, Mr. Gray argues that because his clients are not parties to the case and therefore not subject to the order, he too is due an equal measure of deference and exclusion. The weight of the authority is contrary to his position. In TAP, the Idaho Supreme Court made clear that courts must strike a reasonable balance between the right of free speech and the state's legitimate interest in preserving the integrity of its judicial system. In reaching this conclusion, the TAP court relied on the Gentile decision, which, in the court's words, balanced the state's interest in assuming fair trials against the free speech interest of attorneys. Thus, a case-associated speaker status as a lawyer alters the degree to which their speech is protected. The lawyer versus non-lawyer distinction is recognized broadly elsewhere, even in the cases where the speaker/attorney claims not to be involved with the case in question. In Good, the Fifth Circuit Court of Appeals considered whether an attorney who routinely communicated with and occasionally passed notes to the defense could be sanctioned for violation of the non-dissemination order and the Louisiana criminal trial publicity rule because he was not a lawyer associated with the defense or trial participant, application to whom Good argued the local rule was limited. Rejecting Good's argument, the court relied upon Gentile's own language that because associated lawyers have special access to information through discovery and client communications, their extrajudicial statements pose a threat to the fairness of a pending proceeding since the lawyer's statements are likely to be received as especially authoritative. So there are ways you can still get around this, right? Are they actually involved in the case? It's not potentially they're getting information, but are they actually getting information that's more than just anybody else? And if the answer is yes, then you tell the Gonsalves family as potential witnesses or victims in the case, say, because we're having these conversations with you, now you're subject to the order. Or if they're not actually getting any of this information, should they be limited? I think it's an honest question, a fair question. Similar holdings have been reached across the circuit courts, and they give us a bunch of examples. They have interpreted that the heavy presumption against constitutionality described in Stewart as being unique to prior restraints directed to the press and suggested the Supreme Court's Shepard holding as suggesting a restrictive order limiting extrajudicial commentary of trial participants as an alternative to a prior restraint on the media. Lawyers representing clients in pending cases may be regulated under a less demanding standard than that established for regulation of the press, which nobody's really arguing that it should be the same, but these are what the holdings have. As in good, Mr. Gray has special access to information via his clients. Is it true? Is it not? What information do they have? Are they getting it shared with law enforcement or from the prosecutor? So I think it's interesting that they're saying they have special access to information. And I mean, I would think obviously they have special access to certain information, but does that mean they should be gagged like everybody else that's actually involved in doing this investigation? I think the answer is no. I think they should have some middle of the road limiting instruction to the potential victims and witnesses in the case that's less restrictive than what they have on the lawyers, the investigators, the active participants in the case. Dissemination of information forbidden by the court's order would be deemed authoritative as a result of this access and Mr. Gray's status as an attorney, and therefore would endanger the jury's impartiality. So what that means is if they hear it from Gray, if they hear it from the victims, they're going to take it as true and it's going to affect the jury. And while that is possible, I think there is a way to disseminate or discuss this information. I think we try to do it on this channel as a lawyer I find myself under the rules and codes of ethics at all times in everything I say. I try to stay within those rules. I do everything I can ethically and morally possible in my work and in our discussions here on YouTube to stay under that. And I don't try to make any potential juror bias. I think you all know that. And people have messaged me, I'm going into jury duty. Thanks to you, I am not going to just think this guy's guilty when I show up because he got arrested. And so that's what we try to do. And I think Mr. Gray should also try to do that. And any lawyer that's talking through this process should not try to make a juror more biased towards or against their client. And I think because we are already under these rules of ethics, we should be allowed to say certain things. And if we do violate those rules of ethics, I think reprimands should come down. If Shannon Gray comes and violates the rules of ethics, he should be punished under the rules of ethics. But without any violations, to limit him to this extent, I think is potentially overreaching. Let me know what you think in the comments if you agree. Mr. Gray's First Amendment concerns, while its continued application on him accounts for his apparent authority and special access to the facts. The court's exemption of Mr. Gray's clients from its order effectively answers his First Amendment concerns. All right, IRPC 3.6 is not facially vague, nor vague as applied to Mr. Gray's circumstances. Mr. Gray then argues that even if the court may order him not to disseminate information to the press because the court's order mirrors the language of IRPC 3.6, it's vague on its face and as applied to his circumstances. So I do think it is a little vague. I think you can argue basically everything ever written is a little vague. It's difficult to say things that are still in place are vague and unconstitutional if they're being applied in all these other cases. So that's just a difficult road to hoe just to jump off the jump. First, it's in no way vague on its face. It's like, this is so vague, so obviously vague. It's no way vague. Lawyers love to do stuff like that. Like, make it so obvious that I'm right. What's going on, Judge? The point is premised on a faulty understanding and misreading of Gentile. In Gentile, the Supreme Court expressly stated, we are not called upon to determine the constitutionality of ABA Model Rule 3.6, which we read together in the last video, but only Rule 117, which has been interpreted and applied by the state of Nevada. Moreover, Supreme Court held nothing inherent in Nevada's formulation of the trial publicity rule fails First Amendment review. But as this case demonstrates, Rule 117 has not been interpreted in conformance with those principles by the Nevada State Court. Mr. Gray's assertion that Gentile Court held that the wording of Rule 3.6 and 3.8 was unconstitutionally vague is simply wrong, because Gentile only found that Nevada's rule was unconstitutional as applied. That decision does not mandate a similar finding when evaluating IRPC 3.6. To the contrary, the Supreme Court's express finding that nothing inherent in Nevada's rule failed First Amendment review indicates that the same conclusion is appropriate with regard to IRPC 3.6. As Mr. Gray himself states, is similar in wording to 3.6, to ABA 3.6. They're saying, actually, that holding was much more narrow, saying as applied in this case, a different rule is unconstitutional. But on its face, that ABA rule, or the ones that mirror it, because a lot of states mirror the ABA, the American Bar Association Rule 3.6, is actually on its face, doesn't violate the First Amendment. It's like, actually, that holding says you're wrong, not you're right, which is, funny how different lawyers can read things differently. And that's why we have judges. Mr. Gray's argument that IRPC 3.6 is unconstitutionally vague as applied to his own circumstances is also faulty. In Gentile, the Supreme Court found that one central point must dominate the court's as applied vagueness analysis. This case involves political speech. At issue here is the constitutionality of a ban on political speech critical of the government and its officials. That's in Gentile, not our case. While it is true that Mr. Gray and the Gonsalves family have criticized the police in this matter in the past, since Mr. Kohberger's arrests, their statements have been focused on him. See this interview with the father of Mr. Gonsalves saying that Kohberger was overwhelmed in court. I don't know why that's an unfair statement. I don't think that biases a jury. Okay. Additionally, and they're going to say like the way that they're talking and they're going to say stuff about Kohberger, they're going to say this is the guy. I feel like maybe they have said it in some interviews, but other interviews they're saying, we hope this is the right guy. We hope it seems like they've got a strong case. I mean, that seems okay. That seems fair. I don't know. Additionally, at issue in Gentile was the confusion created by the safe harbor exception for statements by the defense about their defense. Mr. Gray has essentially agreed his client is not a real party to this action and has nothing similar to a defendant's interest in stating their defense with the press. Thus, the vagueness found in Gentile is an opposite of his concerns. So, in Gentile as well, it seems like, I didn't read the case. I have read it before, I believe, but that this was a defendant saying, we need to be able to make these statements in order to make sure we have a fair defense, which obviously we talked about how having a fair defense is one of the most important things throughout the entire process. So in order to have a fair defense, we got to make sure that we protect their rights. Mr. Gray has admitted in this situation, these are not even parties. So their rights are secondary to the parties in the case. Some people don't like that kind of language because they are victims of the case. As an attorney, Mr. Gray cannot claim vicarious exemption from the rules of professional conduct and thus is therefore bound by our IRPC 3.6. So this is interesting, especially when we think about Waldman and we think about Bertolino, if you know those cases with Depp and Gabby Petito, how lawyers' statements are being held to be their clients and their own in certain situations. So this is interesting. Finally, Mr. Gray asserts that he is allowed to relay to the media any of the opinions, views, or statements of those family members regarding any part of the case, regardless of the rules of professional conduct. I don't think that's quite what he said, and I would disagree with it if that is what he said. I think we're always under the rules of professional conduct, like I said, and I think the reason that we are the mouthpiece to the victims and their families is so they can say whatever they want to us because we're their lawyers, they're trusted confidant, and then we can figure out the right way to say it to the press, the appropriate way, the ethical way, the moral way to say it to the press. Because it would place an undue burden on the victims' families if the attorney whom they retained to represent their interests was prohibited from serving as their spokesperson to the media and other parties in transmitting the victims' thoughts and opinions. This assertion of vicarious exemption from the rules of professional conduct is plainly baseless. And I will just tell you, I'm going to give my guess. I don't know Shannon Gray, but we've listened to a lot of interviews. If he wanted to violate the rules of professional conduct or the ethical rules for lawyers, he would have done it already. It doesn't seem like he's that kind of guy. It doesn't seem like he's taking the low-hanging fruit and trying to just get 15 seconds of fame in this case. So I don't think he's looking to be exempt from the rules of professional conduct. I don't see that in him so far. Let me know if you disagree in the comments. Besides being entirely inconsistent with the above provided precedent, Mr. Gray's position on the issue is contrary to the long-held acknowledgement that even outside the courtroom, lawyers in pending cases are subject to ethical restrictions on speech, which an ordinary citizen will not be. I agree with that. I don't agree that Mr. Gray disagrees. Such has always been the case. A membership in the bar is a privilege burdened with conditions. Agreed. Mr. Gray's representation of the Gonsalves family does not entitle him to the same degree of freedom of speech they enjoy as ordinary citizens. Further, Mr. Gray makes clear that if his motion is granted, he will comment on the case and other issues surrounding the investigation pursuant to Rule 3.6. What portion of Rule 3.6 Mr. Gray invokes here is an open question, insofar as the rule addresses Mr. Gray's intended subject matter. It expressly identifies it as a subject more likely than not to have a material prejudicial effect on a proceeding, particularly when they refer to a criminal matter or any other proceeding that could result in incarceration. Indeed, the rule notes that a criminal jury trials will be most sensitive to extrajudicial speech. Here's what I'll say before I read the last paragraph. If you do what I'm suggesting and make a more limiting restriction on speech, and you tell them, if you violate it, if you toe the line, if you go further, we're expanding it again because you've proven our point. And you've created a situation where a juror might be biased based on what you state. if you disseminate information that is not public or that is something that people would not know or with certain authority because you're a lawyer or because you represent the victims' families, again, we will restrict it more and potentially report you to the bar. And just remind him and say, listen, do your job and we should all be fine. And if I'm Shannon Gray, I'd say, thank you. That's all I'm asking for. Let me do my job. Let me represent these people. Let me make statements on their behalf, because this is a tough process for them. And this is something that may help them throughout this process, because it would be really interesting if the victims' families came out and said something and the judge took issue with it, say they violated the court order. What's the judge really going to do? Sanction them, throw them in prison, fine them when their kids were brutally murdered? I don't think so. So I think if everybody can work together, that's probably the best situation. And again, I understand, if we're seeing it in the Murdaugh case, some lawyers start to hate people and they seem to like lose their interests in justice. But Mr. Gray should want, and I think he's even stated in interviews, a fair trial, a proper trial for Brian Kohberger. Brian Kohberger's rights will be intact, and that if he did it, he gets convicted. He gets convicted the right way with no appellate issues. That's what we should all want. And if he didn't do it, to hope that he does not get convicted. Mr. Gray argues he will not be offering up his own opinions regarding the facts surrounding the case, but rather only serving as his client's spokesperson or conduit to the media and other parties and transmitting the victim's family's thoughts and opinions. Seems fair to me. Doesn't seem like he's trying to violate professional conduct or ethics rules. Far from mitigating the already tenuous nature of his agreement, this signal of intent again places Mr. Gray at odds with Rule 3.6 and Gentile. The court has already exempted Mr. Gray's clients from its order, adequately preserving their First Amendment rights. To the extent this exemption to Mr. Gray would only function solely to grant potentially prejudicial statements that weight recognized as danger by the Gentile court on a subject the rule distinguishes as already extremely susceptible to prejudice. So they're saying the victims' families want to talk, they can talk. The court is not going to sanction them. They're not going to throw them in prison. But if they speak through their attorney, they may sanction their attorney. I don't really get it. If the victims can speak out, why can't their attorney speak out on their behalf? I don't understand it. Because he has more authority because he's the attorney. I actually feel like the victim's dad has more authority to people listening, and people are more likely to maybe sway their opinion on something if it's the victim's family member that's speaking versus their lawyer. If Mr. Gray truly intends only to voice his client's thoughts and opinions, then the court's previous exemption has already cured the supposed First Amendment infirmity. Mr. Gray's clients may voice these thoughts and opinions themselves, as they have clearly been doing. The sole effect of maintaining the court's order in present form is the continued operation of a remedial measure that prevents prejudice at its inception. Mr. Gray is bound by the rules of professional conduct, and the First Amendment does not excuse him from that obligation. So, I mean, to me, this almost feels like lawyers arguing just to argue. I think Mr. Gray should be able to speak on his client's behalf. I think he should be subject to the rules of professional conduct. He should be subject to the rules of ethics. He should not be trying to poison a jury pool. And I don't think he has to this point. And I think if the clients are allowed to speak, I think they're allowed to hire somebody to speak on their behalf. So they could hire a PR firm to speak, but because he's a barred lawyer, he can't. I mean, come on. That just doesn't make sense to me personally. I think if they're going to let the victim speak, even though they're potential witnesses, then they should let the lawyer speak on their behalf. I think you can limit it. I think you can bring it to them and say, if you guys push this, it's going to become a problem. And I, as the judge, will rectify that problem. So don't push it. I think that's all possible. All right. So we have that. Let me know what you think. Let me know what side you land on there. And we're going to finish up today's video with, I just copy and pasted this in a Word document, which I think I can share. Let's see. Certain window, Microsoft Word. Hopefully this is the right one. All right, it is not sharing. So here we go. I will read it to you, okay? This is the supposed termination letter. And we are going to find out later on, I guess, if it's legit or not. It seems legit enough to me. And the timeline is really interesting to me. And I think something that could definitely be used by the prosecution in prosecuting Brian Kohberger. Mr. Kohberger, I am writing this letter to formally inform you of your termination of your teaching assistantship with the Department of Criminal Justice and Criminology effective December 31st, 2022. So my first question is, if he really was terminated at the end of the fall semester and was not going to have this job that's probably very important in his PhD program, was he even ever going to come back? Did his dad fly out to drive back with him just for Christmas break because that was it and he wasn't going to come back? Seemed like he left a lot of his stuff there if that was the case. So some of it, is contradictory, but interesting. The letter reads, in keeping with the Washington State University Graduate Student Handbook, Chapter 9G2 and 12E3, below is the list of events that led to you being deficient on the following contingency clause of your funding, meaning funding his TA, him being a TA. Maintaining satisfactory progress in fulfilling assistantship service requirements and duties. So not being aggressive, not beating people up or fighting people, but you didn't do your duties and your requirements. Now, here's an interesting timeline. On September 23rd, you had an altercation with the faculty you support as a TA, Professor Snyder. I met with you on October 3rd to discuss the norms of professional behavior. And then on October 21st, Professor Snyder emailed you about the ways in which you had failed to meet your expectations as a TA. As a result, on November 2nd, Graduate Director Willits and I met, not me, the person writing this, met with you to discuss an improvement plan, which you agreed to, and I shared with you in an email dated November 3rd. We met again on December 7th. So November 3rd, then to December 7th. Okay. November 3rd, when he was having these problems, they put a plan in place. He agreed to it. It seemed like he wasn't fired at that point because we know the murders occurred just after November 3rd and before December 7th. So between these two pieces in the timeline. So on December 7th, when you met with Professor Snyder and Dr. Willits and I to discuss your progress, while not perfect, we agreed that there was progress. So the whole he lost his job, he must have snapped, that's why he committed these murders, kind of falls apart there, if that's true. Because December 7th, it seemed like he was working in the right direction. On December 9th, there was another altercation with Professor Snyder in which it became apparent that you had not made progress regarding professionalism and about which I wrote to you on December 11th requesting a meeting. So 7th, everything was fine. 9th, it fell apart when there was another altercation. Then they met on December 19th when I informed you of your termination as a TA for the spring semester. Fits into the timeline when he went home. Also interesting is if we're going to take the other times his phone was going around the location of the murders, was it him stalking his prey or planning? Doesn't really fit into this timeline. So while I think the prosecution will definitely try to use this to show his world is falling apart, he's got nothing to lose, he's going to get fired. So boom, he does this for, a number of reasons. Is he trying to write a book? Is he trying to do his thesis? Is he trying to go based off his Reddit thread or whatever? Why is he doing this? We don't know. But look, he was losing his job. I think there's just as much evidence for the defense to say no. As far as it comes around December 7th, everything was on the up and he was improving. And that was after the murders occurred. So he was still in line to keep his job and progress in his job. Now we'll see if we hear from, which I bet we will. I bet there'll be prosecution witnesses, Professor Snyder, who he kept getting in altercations with. My guess is that's going to be a witness for the prosecution. So we're going to learn some names here of people that were with Kohberger and can testify about how he was acting, what he was doing around this timeline. And I think that's one of the really important things about this timeline, if it is correct in this termination letter, is what will these people say he was doing? How was he acting? How did he change? And how does that affect the Idaho 4 murder case? So just another little piece of potential evidence that I did want to read here and just discuss with you and get your thoughts in the comments. Let me know. If you guys enjoyed this video, hit that like button and keep it coming on what content you guys want to hear most, and we will keep bringing it to you. Thanks for being with us today. Until next time, I'll see you tonight. We'll talk Murdoch. All right, take it easy, everyone.